Good day, our esteemed listeners, viewers, and followers. Welcome to another exciting edition of Let's Talk with Asset Litigation. As usual, I am your host, David Onon Joko, and I will take you on this very wonderful sail. I'll be your captain in today's ship. I will promise to sail to the waters of knowledge and then drink from the fountain of wisdom. That is the legal wisdom we are talking about here. Today, just like every other day, we are going to be discussing a very important and pertinent topic. And the topic today is, can a tenant restrain his landlord from increasing his or her rent? I repeat that. Can a tenant restrain his or her landlord from increasing his rent? Now, why this is important is because Nigeria has a very large housing deficit, which goes to one house to about 50 persons. That is, one house has to about 50 citizens. That shows that we have a huge housing deficit in Nigeria, and it is important that we discuss this pertinent issue. As usual, we are going to be starting off with a wonderful story. This story has to do with my friend Kwesi. Kwesi has high taste for living in a hybrid environment with rich neighborhoods, and he decides that he's going to rent an apartment within a certain hybrid area in Lagos State. Kwesi, after renting the apartment and staying for the first year, the subsequent year, he was now served a letter from his landlord notifying him of increment of his rent by over 60%. And Kwesi, this time around, is confused and wants us to assist him with some legal advice. Now, the name Kwesi used in this very story is not intended for any other purpose other than educative purpose. It is not the Kwesi that you know or the Kwesi that you are imagining. It is just for the sake of telling our story and giving clarity to our discussion for today. As we said earlier, housing and shelter is a very important necessity of life, and everybody needs a shelter after a day's job. And it is as a result of the housing deficit in Nigeria that has necessitated this topic for today, because many persons who seek houses don't own houses, and that is why they are seeking for shelter. And those persons who are few that own houses, we want to maximize profits of their investment, and because of this, it has given rise to one-time and unnecessary and incessant increment in rental value of properties. Before we go deep into today's discussion, we have to understand the basic concept. Who is a landlord and who is a tenant? A landlord simply means a person who owns a property and rents it out to others who pays him for that rentage. Now, that simply means that for you to be a landlord, you must first of all be the owner of the property. By owner of the property, that means you must have the highest interest. No other person should have a greater interest in the property than you. That means you own the property. The property belongs to you. The property, the title of the property is not being contested by another person other than yourself. That is the number one criteria of being a landlord. You must be the owner of the property. Then number two, you should then rent it out to others. This is not a basic ingredient of a landlord, because renting a property it's not necessary, because a landlord may decide to live in the property and not to rent it. But once he rents the property, he is a landlord for that purpose of the renting, and then the tenant only occupies the property. Now we're going to discuss who is a tenant. A tenant simply means a person who pays rent for a residential or commercial property. That means a person who is not a landlord but occupies a property and then pays rent for that property. So you cannot ask yourself, which category do you fall under, a tenant or a landlord? The answer is best known to you. And as we have said, most tenants will want to look for apartments that befit their standard, or they just want an apartment they can lay their head after a day's job. And then most landlords will want to maximize profit or have maximization of return on investment on their property, and so they will want to increase the rent of the property at will or as often as possible. Now we must strike a balance, and it is in the process of striking a balance, and that is why law came in to ensure that there are regulations, and this regulation has to do with regulating the relationship between a landlord and a tenant. So we are going to be looking at the factors that necessitate rent increment. What are those factors, ingredients that necessitate rent increment? Number one is inflation and high cost of property maintenance. Now, when there is inflation in the society, or which affects the cost of maintenance of a property. Remember, the landlord had to buy cement, had to buy building materials, had to roof the property and keep it in a tenantable state. Keeping it in a tenantable state simply means he has to be maintaining the property to ensure that the property does not go into unusual wear and tear, and then damages or collapse. So in maintaining this property, it has to do with what is the prevailing market price of materials used for maintenance. And so when there is inflation in the society that affects the prices of these maintaining materials, then it's going to affect the cost of rent or the rent rate paid for a property. Number two is increment in government taxes and charges. Now, once government has the duty or the obligation to take what we call land use charges on property. They equally take what we call ground rent and rack rate on the property. They equally take what we call tenement rates on a property. So whether ground rent, rack rent, tenement rate, or land use charge on a property, if government increases the amount, the rate, the tax they collect on this very property, then it will definitely fall back the rent, because the landlord will want to maximize profit and then maximize his return on investment. So he will push the increment on the tenants. And how best can he do it other than increment in rent? Then the third factor that affects increment of rent is the cost of similar properties within the neighborhood. For example, I could see my friend that decides to go live in a hybrid area of Lagos. Now, that area he has, we said in our story, is an area that has rich neighbors. And because it has rich neighbors and it's a touch area, it's a serene area, it's a classy area, an exclusive area, just like a government reserve area in Lagos. Because of that very attention given to those areas, the price of the rent definitely will not be the same with some other densely populated, unconducive, and very noisy neighborhood. So as a result of that, many rich persons will want to live within that area, and that will ordinarily increase the price of rent, the rental value of properties within that area. And so that may be one of the reasons why Kwesi's landlord decided to write him a letter a year after him occupying the premises, that he intends to increase the rent by 60%. Now, the fourth determinant is the forces of demand and supply. So if we have too many persons, too many potential tenants chasing few residential properties available, then it will definitely lead to increment in rental value. As they say in basic economics, where there is excess demand as against little supply, then it will affect the cost of properties. After having discussed this, now we have to go into the laws that governs the landlord-tenant relationship. And in this instance, we are going to microzone the topic into discussing just that of Lagos, because Lagos is very prominent, is in the heart of Nigerians, being not just being the most populated state in Nigeria, but also being the commercial capital center of Nigeria. Now in Lagos, the law that governs the tenant-landlord relationship is the Lagos State Tenancy Law of 2011. And before this Lagos State Tenancy Law, we used to have the Rent Control and Recovery of Residential Premises Law of Lagos State. Now, the difference is that this Recovery of Premises Law, that is Rent Control and Recovery of Premises Law of Lagos State, provided for rent rates in different parts of Lagos. But it's not, that provision is not made in the Tenancy Law of Lagos State of 2011. That is to say, it left the rent rate to be decided by agreement between the landlord and the tenant. Because as they say in law, the law cannot make contracts for parties. Only parties are allowed to make contracts. So the Tenancy Law of Lagos State allows the landlord and the tenants to freely make the terms of their contract, which include the rent rate to be paid by the tenant. So the tenant has to look out for the what is the rental value of this property that I want to occupy. Now, if the rental value is convenient for him, he can go ahead and then sign the dotted lines and occupy the premises. But if it is not convenient for him, he can take a bow and then look for another premise to occupy. Now, one of the basic features of the tenancy law is what we call the rent review clause. Now, the rent review clause is that clause in the tenancy agreement that allows the landlord to review his rent within a specific period of time. Now, this reviewing of rent, definitely review can be upward review or downward review. But you know that in Nigeria, you can never have a downward review of rent by landlord. It will always be an upward review. So it's safe to say that it is the upward review clause of a tenancy agreement. Now, every tenant must look out for this rent review clause, or what we call the renter clause. Now, you have to look this for two reasons. Number one, to know the duration when the landlord will be allowed to increase his rent. Then number two, to know or ascertain whether the landlord can unilaterally, that by unilateral means on his own, without consulting you as a tenant, increase his rent. I repeat, there are two reasons for you to look at for the rental review clause. Number one, to know when the landlord can increase his rent. Number two, to ascertain whether the landlord can on his own, without consulting you as the tenant, increase the rent of the property. Now, if you look out for this rent review clause, you must ensure to protect yourself, because the tenancy agreement is meant to protect both the landlord and the tenant. It is not biased. It's not supposed to be one-sided. So it is left for you as the potential tenant to ask for the tenancy agreement so that you go and review it. If possible, get the services of a lawyer to advise you on clause-by-clause interpretation of the tenancy agreement before you sign those dotted lines, because you don't want to sign what is going to affect you negatively tomorrow. Let's go back to our story of Kwesi. If Kwesi's tenancy agreement, assuming it's stated there that the landlord cannot increase the rent of the property until after 2 years of the tenancy of Kwesi, that means Kwesi has a right in law to tell the landlord that the landlord, I've only stayed for 1 year. Meanwhile, the rent review clause in the tenancy agreement said it's only when I've stayed for up to 2 years that you can review the rent. So since I've just stayed up to 2 years, you cannot review the rent, and I'm entitled to apply for an extension of my tenancy and still pay at the initial rent which I paid earlier. Also, assuming the rent review clause in the tenancy agreement of Kwesi stated that the landlord cannot increase the rent except after consulting Kwesi and both parties agree on the new rent. If the tenancy agreement stated this, then Kwesi will approach the landlord and tell the landlord that you never informed me that you want to increase the rent, so that we can now sit down and then discuss what should be the appropriate and reasonable new rent for me to pay. And since you never consulted me and we never arrived at an agreement on the rent, new rent to be paid, then you cannot enforce the increased rent on me as your tenant. So you see why it is important that Kwesi doesn't just sign a tenancy agreement, but ensure that the rent review clause in his tenancy agreement provides for duration within which the landlord can increase his rent, and then two, provides that the landlord should consult him and there should be in agreement, mutual agreement between the landlord and the tenant of when the rent or how much the rent should be, the new rent should be. Having stated this, it is important to note and to take into cognizance that the amount payable in every increment of rent is based on agreement, okay, except where it is stated otherwise in the tenancy agreement that the landlord can unilaterally increase the rent. For the fact that you are a tenant and you are occupying the premises of a landlord does not give the landlord that godlike figure that he can unilaterally on his own increase your rent without consulting you. And that is why where the rent review clause is not in the tenancy agreement at all, the landlord cannot increase the rent without making or reaching out to the tenant, and then the tenant and the landlord having an agreement of what the new rent should be. Having said this, it is important to equally understand and note this, that the rent review clause of every tenancy agreement must ensure that the new rent must be reasonable. It mustn't be an unreasonable increment. For example, the question is what is reasonable and what is unreasonable in terms of the amount of rent that has been increased. Let's go back to our story of Kwesi. Kwesi's rent was increased a year after he occupied the premises, and then it was increased by 60%. Let's say he was paying 1.5 million naira or 2 million naira in as initial payment when he moved in for rent, and it is now increased by 60%. That means Kwesi will be paying about 3.2 million naira the subsequent year. So the question is it reasonable? That new rent of 3.2 million naira, is it reasonable for Kwesi to pay that rent? Now, reasonability has standards when it comes to rent. The court will have to look at what is the prevailing rent payable for similar properties within that neighborhood. So if, as we said, this is a rich neighborhood and every other person, every other landlord within that neighborhood, none takes less than 3.2 million naira as rent, annual rent, and Kwesi's rent has been increased by 60% to meet up 3.2 million naira. Kwesi cannot say that that new rent is unreasonable, because within the environment he stays, similar properties goes for that amount. So as such, that amount cannot be said to be unreasonable. But assuming it is 60% increment, but properties of similar feature, okay, within that environment or that neighborhood goes for 2.5 million naira. What is planned increases by 60% to make it 3.2 million naira. The law will say, the court will say, no, that new rent of 3.2 million naira is unreasonable, because that is not the prevailing rent for similar properties within the neighborhood where Kwesi is residing. Having stated this, now we go to things that a tenant should do when his rent has been increased. Number one, you have to approach your landlord to negotiate the new rent. Okay, so if the landlord has increased the rent and he informs you by a letter that my good tenant, I want to increase my rent, and I want my rent to be, instead of 1 million naira, to be 1.5 million naira, the subsequent year to renew your rent, you as the tenant should approach your landlord, because that letter of increment or notice of increment of rent he sent to you is an offer in contract. Because as we said earlier, the relationship between the landlord and the tenant is governed by the law of contract. There is nothing, except where the parties agree, there is nothing that should be done without the agreement of both parties, that is the landlord and the tenant. So that letter of increment, notice of increment, is not the increment per se, but rather it is a notification that I am desirous to increase my rent as your landlord. So he is now inviting you to say, let's negotiate, let's talk the new deal, what should be the new rate for you to pay, and then you should approach the landlord to negotiate that new rent. That's number one thing you should do. If after approaching the landlord to negotiate the new rent, and the landlord insists that I want to take this new rent, I don't want to compromise, I don't want to shift ground, you as a tenant, you have the right to apply to court, and this time around, depending on the amount of the rent, to apply to court for the court to declare the new rent as demanded by your landlord as being unreasonable. Now, it is in the process of declaration of the rent to be reasonable, or determination of the rent, the new rent as reasonable or unreasonable, that a court is going to take into cognizance the prevailing rental value of similar properties within the same neighborhood as the property in contention. And it is only in this very instance that the court cannot declare the new rent to be reasonable or unreasonable. And in Lagos State, take note of this, in Lagos State, where the court declares the new rent to be unreasonable, the court has powers to fix the rent to conform with the prevailing rent of similar properties within the same neighborhood as the property in that the rent is a contention. Also, where the tenant has exhausted his tenancy, the period of his tenancy, but stayed over in the property, and the reason why he has not been able to pay his rent is because the rent, the amount paid to be paid as rent, is in contention, but he is willing and desires to pay the rent, he can apply to the same court, asking the court that I am willing to pay the rent, but I'm only willing to pay the old rate, or I'm only willing to pay the prevailing rate for similar properties within the neighborhood, and it is within his rights to do so, and the court will so hold. If the court finds out that the new rent that the landlord demanded is unreasonable, as I said, reasonability or unreasonability of the new rent is a matter of fact that is only evidenced, or that can only be proved by providing evidence of similar properties within the same neighborhood, the rental value for such similar properties. Now, having established this, we will now come to the conclusion that yes, a tenant can restrain his landlord from increasing his rent. One, where the new increment is unreasonable. Two, where the landlord unilaterally, that is on his own, without consulting the tenant, decides to increase the rent. And three, where the tenant disagrees with the landlord on the new rate or the increased rate of the rent, as or as a result of the rent not the review of the rent, the time period for reviewing the rent has not lapsed. Having established this, we come to the conclusion of today's edition of Let's Talk with Asset Litigation. I hope it was an educative and very insightful episode for you. We would like to hear your feedbacks, comments, questions, and suggestions. Please do this by leaving a comment at the comment section of this streaming platform where you are watching me from. And we promise to respond as soon as possible. Until we meet again, I will say thank you so much for staying tuned, and you already know that we here in Law Ascent, we have you so dear in our hearts. Thank you, and God bless you.